Yes.
And you have agreed that Mr. Ozentoski is going to make periodic payments directly to you in the amount of $1,000 per month. One half of that's going to be paid on the first day of each month, and the other half will be paid on the 15th day of each month. And the first payment will be March 1st of 2025, correct?
Yes.
And these spousal support payments are for support. They are not property settlement, and they are going to be taxable income to you. And it's not dischargeable in the event of bankruptcy, and the support will stop if you get married, if either of you die, or when you turn 67, correct?
Yes.
And we have attached a uniform support order, and that's going to be made a part of this judgment by reference, correct?
Yes.
With regard to any life insurance, any right or interest that either you or Mr. Ozentoski has to any policy or contract of life, endowment, annuity insurance of the other as a beneficiary is extinguished, and you're each free to choose beneficiaries of your own choice, correct?
Yes.
With regard to the 2024 state and federal tax returns, you are going to file jointly for the 2024 tax year and divide equally any refund or liability, correct?
Yes.
With regards to retirement benefits, you are awarded an interest in the defendant's Carpenters Pension Trust Fund through the Michigan Regional Council of Carpenters Fringe Benefits Fund. And that's going to be pursuant to a separate order that's called a quadro to divide those benefits, correct?
Yes.
And we have actually prepared a quadro, and that is attached to our judgment as well today, correct?
Yes.
And you both signed that?
Yes.
Okay, and then any right or, other than that one plan, any right or interest of either you or Mr. Ozentoski to any other pension, annuity, or retirement accounts of the others extinguished, and each of you hold your own pension, annuity, and retirement accounts, including the right to choose a beneficiary for survivor benefits, free and clear of any claim of the other, and each of you are making an explicit, voluntary, and good faith waiver of any right you may have in surviving spousal benefits, correct?
Yes.
And then you will retain the services of a pension specialist to provide the qualified domestic relations order, which we have already done, and you're each responsible, or no, the defendant's going to be responsible for that fee, correct?
Yes.
The property settlement, you are awarded as your sole and separate property, free and clear of any claim by Mr. Ozentoski, the real property located, and you are going to pay any and all indebtedness owing on that property awarded to you and agree to forever hold harmless and indemnify him therefrom, correct?
Yes.
And he is not on the deed, correct?
Yes.
So he's not on the deed.
No.
Right.
No, he's not.
Sorry, I asked that backwards.
No, he's
No,
not.
I think you asked it correctly. It's just,
Oh.
and then when you asked the other question, it was still backwards. So-
Yes.
But he clearly is not.
He is not on the deed, but he is on the mortgage, correct?
Right.
Got it.
And
Yes.
so you have 120 days from the entry of this judgment to refinance to remove his name from that, correct?
Yes.
And you are also awarded as your sole and separate property free and clear of any claim by him. All of the personal property, clothing, effects, and jewelry of every name and nature is presently in your possession, including the 2021 Ford Edge. And you're going to assume and pay any and all indebtedness owing on the personal property awarded to you, and shall forever hold harmless and indemnify the defendant therefrom.
Yes.
And the defendant is awarded as his sole and separate property, free and clear of any claim by you, all of the personal property, clothing, effects, and jewelry of whatever name and nature is presently in his possession, including the 2008 Chevy Silverado, his safe, his guns, and the inherited items from his parents that are still in your possession, correct?
Yes.
And he is going to assume and pay any and all indebtedness owing on the personal property awarded to him and shall forever hold you harmless and indemnify you therefrom, correct?
Yes.
And you shall sign the title to the 2008 Chevy Silverado over to the defendant forthwith, correct?
Yes.
And each of you are awarded any bank accounts in your individual names, and you are each responsible for any credit cards or any other debts in your individual names, and you'll indemnify and hold the other party harmless therefrom.
Yes.
And then each of you shall assume and pay as your sole and individual obligation any indebtedness incurred by either of you in an individual capacity on or after the date the complaint was filed in this matter, and shall forever hold the other party harmless and indemnify them therefrom, correct?
Yes.
And the two of you shall execute any necessary instruments to effectuate transfer of any property. If you do not sign the necessary documents, then a certified copy of this judgment may be recorded with the Register of Deeds or Secretary of State with like force and effect.
Yes.
And then we have also included the mutual bankruptcy clause, disclosure of assets, bar to all claims, release and satisfaction, enforcement expenses, the plaintiff attorney-client clause, independent advice of counsel, the tax advice clause, and when the judgment is final, correct?
Yes.
And do you want your maiden name returned, or do you want to keep Ozanowski?
Keep us in custody.
Okay, and you understand that this circuit court will retain jurisdiction over the property settlement until all the provisions are complied with, correct?
Yes.
Okay, can you think of any other debt or any other property that you have out there that we have not thought about or taken into account in this judgment of divorce?
No, I don't.
And do you want the judge to grant your divorce today?
Yes.
And you realize that you could have had a trial on this where you could have come out better, worse, or substantially the same. And by asking the judge to grant this, you're waiving your right to a trial and you're accepting the settlement, correct?
Yes.
And are you satisfied with my representation?
Yes.
I have no other questions for that.
Thank you, Ms. Ferris. Regarding the spousal support, this is non-modifiable spousal support for a particular amount of time or remarriage or death, correct?
Correct.
Okay, just wanted to be sure. Would you please question the defendant?
Yes.
Thank you.
Would you please state your name for the record?
Kevin Osentoski, Osentoski.
And are you the defendant in this complaint for divorce?
Yes.
And did you hear the settlement agreement that I placed on the record?
Yes.
Is that your understanding of the settlement agreement that's been reached?
Yes.
And can you think of any other debts or any other property that's out there that we have not taken into account in the judgment of divorce?
No.
And would you like the judge to grant your judgment of divorce?
Yes.
Thank you. I have no other questions, Your Honor.
Thank you, Ms. Ferris. Based upon the testimony presented, the court finds that the statutory grounds for divorce have been established. Therefore, a judgment of absolute divorce is granted to the plaintiff, Margaret Osentoski, for the defendant, Kevin Osentoski. There are no minor children of the parties. Spousal support is awarded pursuant to the agreement stated on the record. The divorce judgment shall include the property division that was outlined in the record as well, including provisions concerning pensions and life insurance. The court has reviewed the proposed judgment as well as the accompanying support documents, as well as the qualified domestic relations order. It comports with the testimony. The court has executed those documents. We'll hand those to the court administrator, who will provide those to Ms. Ferris, who will have the file with the court. Thank you both for being able to work out your differences. Ms. Osentoski, make sure you thank Ms. Ferris for the hard work she put in on your case. Good luck to both.
Yes. Thank you.
Defendant's motion regarding parenting time. Parties are present, appearing on behalf of the plaintiff, in this case, Attorney Dennis W. Reed, appearing on behalf of the defendant, is Attorney Mark J. Sacken. Mr. Sacken, you may.
Thank you, Judge. This is our motion, Judge, for change of parenting time. As the court is aware, I'm sure, the parties have been here a few times previously. A very brief background of the case. There's a 2-year-old son, Judge. Their son was born in May. The parties lived together with their son for 1 month. After that point, Mr. Yan moved to his grandmother's house, which is a 4-bedroom house. There was a stipulated order put in place through this court in October of 2023, providing the parties with joint legal custody and Ms. Marshall primary physical custody with parenting time as the parties may agree, but with the support order providing my client with 0 overnights. Mr. Yan, even though he was given 0 overnights, there were no issues that caused out his background. He never had any criminal background issues. There were no allegations of any drug use or any concerns about his parenting time other than he hasn't been a father before. Mr. Yan agreed to that because he believed that the parties would be able to work together for his parenting time to reasonably increase as time improves. And he thought he'd have reasonable parenting time immediately as well. From the outset, Ms. Marshall only allowed him supervised parenting time at her house every Tuesday and Thursday. He filed a motion in January of 2024 for increased parenting time. It was denied by the friend of the court, but referred for I believe a mediation of sorts.
You said it was denied by the friend of the court?
Well, I'm sorry, it was denied but the motion was denied by this court, but referred to friend of the court, I believe. I apologize, Judge.
Okay, I don't think it was denied. It was front of the court to do, to consider alternative dispute resolution.
Okay.
And my understanding of that was the parties were to meet with the front of the court, and at least reading the pleadings and the files early on before you got involved, Mr. Sackett, there was an agreement for the ADR. There was ADR. Reportedly, there was some sort of an agreement that was made. And was it even signed, Mr. Holbrook?
The ADR report?
Yes,
Yes, I do believe so. That is
by
the-
both parties.
No, that was. It was one regarding custody that was submitted to the court, that the court had signed.
Judge, we've actually been to two meetings with the friend of the court where agreements were made, so there may be two reports in there.
And I'm not doubting that, but what I've at least seen, and Mr. Sackett, I'm gonna let you continue here in just a second, but it appeared that in reading the file that there was some sort of an agreement in place, but then your client had buyer's remorse and came back, but there's still ADR scheduled here
March 11th, Judge.
coming right up. So what's the proper cause or change in circumstance when ADR is already?
Well, my client, his concern is that there has been ADR twice, I think once, at least once he did agree. The reason, and I believe the other side, as friend of the court stated, perhaps he didn't, because there was a recommendation, is that he feels that the progress, and when he did agree, it was kind of because he felt like, based on his experience with ADR, the writing was on the wall what the recommendation was going to be, which was that his parenting time the recommendation would be significantly of what he kind of reluctantly agreed upon. And as the court said, I guess buyer's remorse may be a term that could be used, but he agreed upon that because he's frankly frustrated with the ADR.
I understand that.
Yeah.
Absolutely. That makes sense.
So at this point, he believes that it would be more equitable from his perspective for this court to make a determination, because his concern is he's going to go to ADR on March 11th, and that the progress based on his experience from his perspective with ADR is going to be incredibly incremental. But to answer your question about what has been the change of circumstances, Judge, and before I mentioned that, I would argue that I believe under the law, because what he's requesting is not a change of custody, but an increase in his duration of parenting time, that the standard under the barcode would be more flexible than a request for a change of circumstances.
Don't disagree with that either.
Okay. And likewise, the best interest factors would be preponderance of the evidence rather than clear and convincing evidence. But to answer your question directly, Judge, we believe there's many changes of circumstances. One, at the time of the order, and even up to more recently, the most recent order, the concern was that Mr. Yan was not an appropriate parent to have overnight parenting time, strictly because he didn't have enough quote unquote experience with young children. But that is greatly changed. In addition to the fact that he has been exercising essentially every single one of his parenting time sessions at Miss Marshall's house, and there, to my knowledge, has not been a single complaint whatsoever about how he's been acting with the child and forming a bond with the child. He also has had the benefit of providing a great deal of child care of other young children at his house. He's now residing with his girlfriend, and his girlfriend's niece has regularly stayed with them, and in fact, approximately for a long period of time, approximately 2 times per week, has been staying overnight. And this is a 3-year-old girl who has been staying with Mr. Yan and Mr. Yan's girlfriend, who's in the court today, where they've been the primary caregivers for that child during those extended periods of time, including bathing, eating, everything that someone would do with a 3-year-old. So to the extent there's a concern that Mr. Yan would be incapable of providing for his own 2-year-old child overnight, I don't think that's a reasonable concern. 2, the previous pleadings in this case have been that Mr. Yan did not have suitable housing, and the allegations were that he was jumping around staying from different houses. The reality was he was staying often at his girlfriend's house at the time. His girlfriend has now moved in to his house, living with him. It's actually the house that's owned by his grandmother specifically, but that home is a 4-bedroom home. That's the only place he's staying. That's strictly where he's staying. More so, that house right now has been toddler-proofed to the extent that there's the cabinets can't be opened. There's toddler-proof door handles to the door. There's a bed for the child. There's diapers. There's wipes. Everything that could be possibly done to care for a toddler has been. There's toddler gates to the stairs. All those things are done in the house right now. So that's a change of circumstance. In the past, there's been issue potentially with child care. because my client, he does work at 6 a.m. in the morning. He was a sanitation worker. As of now, again, there's further childcare that's in place in the sense of his girlfriend and as well as his sister. Stability of employment and stability of his life as well has changed. 2 years ago, I believe either he just started work or he wasn't working as a sanitation worker yet at all. He's now had approximately 2 years of experience nonstop working for Amera Environmental USA as a sanitation worker. So that demonstrates stability in his life. Not that there was any concerns about his history or his drug use, but to work for this company, every 3 months, they perform a background check. Every 3 months, approximately, they perform random drug screens. You fail a random drug screen, you're out. And he has never once had any issues whatsoever. So that's not an issue at all. Unfortunately, another change of circumstance is that there are concerns about the parenting time he's having at mom's house. While he's with mom's house, often there's time, and he's only there for brief periods at a time. Miss Marshall or Miss Marshall's mother are there, and it is often distracting the child to spend time with her rather than him. And that makes it even more difficult for him to exercise and increase his bond with the child. There have been times where he's asked, can I take the child to family events and even return the child? And those requests have been denied. There was a time during his Christmas visit, where he said, listen, can my sister come with me to your house? He would like to see our child for Christmas. That request was denied. His family essentially doesn't even know their 2-year-old child, because all of his parenting time, for some reason, is strictly at Miss Marshall's house, and she controls everything. There's other concerns he's been having with mom at the time for a long period of time. The child has been, what she's been told, co-sleeping in Miss Marshall's bed with her, and he's now a 2-year-old child. He doesn't know whether or not the child has even his own bedroom, his own bed, which he does at my client's house. And I know that Ms. Marshall in her answers say that most recently he missed the parenting time session, and that he didn't contact her till after. That's not entirely the case. This most recent parenting time session, unfortunately, as a sanitation worker, his truck broke down. He showed me a text message just now at 4:30 p.m. prior to his exercising of his parenting time, informing her that his truck did unfortunately break down. When there's two parents exercising parenting time, of course, sometimes things happen. His truck breaking down and him having to finish his route regardless is something that was out of his control, Judge. So, but he's consistently exercised his parenting time. The child is 2 years old now. I don't see any reason. I know in our motion we mentioned Schedule 6. That was a mistake. I should have mentioned Schedule 7. I don't see any reason, Judge, why it would be in the child's best interest for him to have he's not asking for 50-50 parenting time. He's asking for merely alternating weekends and 3 hours on every Wednesday, and then the summer and friend of the court holiday parenting time pursuant to the Huron County addendum, Judge. Thank you.
Right, thank you. Mr. Reed.
No, I filed a brief response with the court. And as indicated to my client earlier, I don't think I've had a case in 40 years of practice where I have been in court so many times in a year on the same issue. This gentleman has come into this courthouse on 3 separate occasions, 3 of them in the past year or so, and made an agreement at the prosecutor's office. We went to the mediation the first time, alternate disputes, made an agreement there. We had a second review, I think in August or early September of 2024, made a third agreement. We've had 3 court orders in place by agreement with this gentleman regarding his visitation with this child. No one's forced him into these agreements. He has made these agreements. And it seems like no sooner than the ink is dry on the order, we're back in here again on a motion of Mr. Yan because he doesn't like it. He doesn't like the agreements he's made. And so we're here with the same argument, in essence, that we've heard twice at least before, where I want more time because. And yet he agrees to what he agrees to when we get to the points where we make these deals. No one's forced him to do this. He's treated very well when he goes to the front of the court's office at the 2 mediation meetings I've been to. Very, very well treated. The front of the court staff is very polite to him, allows him to say whatever he feels like to say. The parties make proposals back and forth. I listen basically as to what's going on. I don't interfere because I've been to 2 of these mediations, and they make an agreement. And as you know, last time he made the agreement, front of the court submitted the order, Roe's order, I think on 7-day entry, and he objected to it because he changed his mind, I guess, and as much as said so in his objections. And Your Honor stated to him that day, I mean, that's not a proper objection, and told him, you have to file a motion if you disagree with something. You don't just file objections. And so the court entered the order, I believe, mid-September, that we're operating under today. And that's the order he's here today trying to change, and it was an order that he had agreed to at the front of the court's office. Now, we went into these meetings, these mediation meetings, in good faith, my client and I. And we agreed to what the court ordered, and we went to these meetings and stated our positions and made agreements. So those orders either mean something, or I guess they don't. And it's our view that they mean something. And we are scheduled for review on March 11th at 3 o'clock in the afternoon. We're going to be there with a proposal. We don't have it today. We will have it on the 11th for him as to where we go from where we are now. But that isn't enough for him, apparently. He wants the court to order it just, I guess, sua sponte today, ex parte even, because I want it that way. Just looking at some basic facts here, he doesn't have the ability to take care of this child at least Monday through Friday because he's gone. He leaves at 6 a.m. and we don't have any idea when he gets home. I bet he doesn't know what time he gets home because it varies. And that's always been one of the issues in this case is his work schedule. And so we've set this visitation up for him to build a relationship with his child around his work schedule. That was one of his arguments last time when he was here with you, and you changed the time to 5 p.m., I believe, because of his work schedule. We're going to make a deal with him of some type, I think, on March 11th. But we agreed to this. He agreed to it. And there hasn't been anything stated here today that should change that agreement that we made at the front of the court's office. Because it's the same argument he always makes. I want more time. Now, firsthand, he tells you I live at my grandmother's home. Well, we dispute that because we believe he's been living in Bad Axe here with a girlfriend. And so he's telling the court I live at my grandparents' home. It's probably his mailing address, I would imagine. There are some issues with this. My client's concerned about who's going to be around her child. If he has a child, their child, I'm sorry, Judge, unsupervised, who's going to take care of this child? We have no idea. These are things that need to be hashed out, and we'll do so on March 11th when we get there. I'm asking the court to do one or two of these, either deny the motion or refer the motion, and we'll deal with it on March 11th.
Second, I don't need a response to this. I can understand the frustration of a parent, and I'm not sure, is this your client's first child as well?
Yes, sir.
Okay, so mom didn't come in with any experience either. Let's be honest. If a parent is fit, a parent is fit. A child should have both parents if both parents are fit. That's the bottom line. That's how the court looks at it. Court is going to take this matter under advisement at this point. Let's see what the mediation or the alternative dispute resolution brings in front of the court's office. I can tell you that the front of the court's office keeps an open mind. They're not pigeonholed in, well, it's always mom or it's always dad. I don't look at it that way. I don't have them look at it that way too. Both are equal parties. Justice is blind and it's in the best interest of the child. That's what it comes down to. We'll have the meeting on March 11th.
11th at 3, Judge.
And then what day of the week is that?
It's a Tuesday.
Tuesday? Can we be here on that Friday? 14th, or is that too early?
I would have to check my schedule, Judge.
Let's just do it this way. We'll set a control date stood up. Let's go a week after. A week after the
March 21st.
March 21. And if that date does not work with either council, call the court, we'll reschedule.
Very good.
I do know that I would be available on March 14th. I am gonna be, my kids' spring break, I'm gonna be out of town on the 21st and the
Okay.
28th.
Let's go back to the 14th. We'll go back to the 14th. If Mr. Reed, that doesn't work, just let us.
I'll have to check, Judge. It's just a busy time of the year. You know.
I get it. I get it. But let's just keep an open mind. Let's see what happens at the front of the court's office. We can proceed from there.
That'd be at 9 a.m., Judge?
Yes, 9 a.m.
Your Honor, just with the alternative dispute resolution that's for the 11th. I know Ms. Eisen is not in the office today, but she had wanted me to ask if both counsel are going to be.
I'm going to be there.
I will, yes.
Okay, that's all we need.
Okay, great. That's how we'll proceed.
Thank you, Judge, very
Motion
much.
preserved. That'll be all. Thank you.
Thank you very much. Do we need to submit an order to that effect?
No. Pro confesso hearing. Plaintiff is present. He's in pro se. He appears via the Zoom application. Court calls Alexandria Kimberly Nicole Avendano. No response. And has anyone checked in? Someone had checked in with initials, but those initials don't match.
Yeah, I have an unidentified cellular device. D as in dog, C as in cat.
Well, matter is scheduled for 9 a.m. It's currently 9:52. The court is going to proceed. Mr. Avendano, would you please raise your right hand?
You solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God.
Yes, I do.
Thank you. Sir, your name is George Alfredo Avendano.
That is correct, Your Honor.
And have you lived in the county of Huron at least 10 days, in the state of Michigan at least 180 days immediately preceding your filing this complaint for divorce?
Yes, Your Honor.
At the time you filed this complaint for divorce, was your spouse a resident of Huron County or of Muskegon County?
At the time of filing the divorce, she had moved to Muskegon County, but had only been there a week, 2 weeks, perhaps.
All right. And is it true that you were married September 21, 2020 in Midland, Michigan by a person authorized to perform marriages in the state?
Yes, Your Honor.
Is it true you stopped living together as husband and wife on or about July 22nd of last year?
Yes, Your Honor.
What was your spouse's prior surname before the marriage?
Before she was married to me, she was Alexandria Collins, Your Honor.
Collins?
That is correct.
Thank you. And you've always been known as George Alfredo Avendano.
Yes.
There are two minor children of the marriage, initials only, LUA and GAA.
That is correct, Your Honor.
And is LUA now 4?
Yes, he is.
And is GAA now 3?
Yes.
Okay. As far as you know, is Ms. Avendano currently expecting?
No, she is not.
You've alleged in your complaint for divorce that there's been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood the marriage could be preserved. Was that true at the time you filed the complaint, sir?
Yes, Your Honor.
Still true today?
Yes.
Briefly, in your own words, can you state to the court why you feel the marriage cannot be preserved?
I believe at this time we just have irreconcilable differences. She has
Any
her own-
chance of reconciliation?
Not at all, Your Honor.
If the court did not grant you an absolute judgment of divorce, would you be willing to resume a husband-wife relationship with the defendant?
No, not at all.
A proposed judgment has been submitted to the court where it indicates that both you and your mother shall have joint legal custody, but you would have physical custody of the minor children. Is that correct?
That is correct, Your Honor.
Do you feel that that's in the best interest of both minor children?
Yes, I do.
All right. And you're aware that each party must notify the front of the court of any change of address or employment?
Yes.
And is it also true that domicile of the minor children shall not be removed from the state of Michigan without prior approval of the court?
Yes, Your Honor.
Okay, thank you. Regarding parenting time, the proposed judgment indicates that mother will get the two minor children for visitation every other weekend from Friday to Sunday. Is that correct?
That is correct, Your Honor.
Do you have times that that parenting time is to occur?
Um, in exchange, yes. The way that it seems to work out with our schedules, pickup or exchange between us is around 7 p.m. on Friday. And then we've agreed or worked out no later than 4 p.m. on Sunday is when I usually get them back.
4 p.m.?
Yes, Your Honor.
Was there ever any discussion regarding holiday schedule?
No, we have just been working with each other, kind of doing like you get this holiday, I get this holiday, you know, changing one for another kind of deal. But
Has that
no
been-
actual discussion.
Okay. Has that been working out?
Yes, it's been working out very well.
What are your thoughts of when it comes to the holiday schedule? It's as the parties mutually agree, but if not, you would adopt the holiday schedule where you would be parent A, Huron County Parenting Time holiday schedule, you'd be parent A and mother be parent B.
That would work for me, Your Honor.
All right, was there any discussion regarding child support?
I have applied for state aid, and so in that, I believe she was automatically put on child support.
There is currently a support order in place, Your Honor, of $103 per month. And that was effective August 1st, 2024. That calculation was started in September of 2024 and was completed December 11th of 24. And according to the file, we have not received any information from the defendant. So she would have been imputed wages.
All right, so are we continuing that then?
That's done and entered. So I guess that would be to the court, yeah.
Okay. All right, so it's been $103 up until near the end of the year here.
Mhm.
Is that what you wish to have continue at this point?
At this point, yes, Your Honor, that's fine.
Okay. Neither party would be awarded spousal support, and that issue is forever barred, correct, sir?
That is correct, Your Honor.
Each party be awarded the personal property currently in their possession, be fully responsible to pay debt, any debt related to that property, with the other party having no claim. Is that correct?
That is correct.
The property's already been divided, sir?
Yes, it has, Your Honor.
Thank you. Are there any debts to be divided?
No, no debts to be divided.
Excuse me. Each party would keep their respective motor vehicles in their respective name and possession, be fully responsible to pay any debt related to that vehicle. The other party would have no claim to it. Is that correct?
That is correct, Your Honor.
Do you own any land or homes? Either party?
We had a home that was foreclosed on.
All right. Any pension, annuity, or retirement accounts?
No.
Any life insurance carrying any cash value?
No.
Also appears that for purposes of tax exemptions, you would be claiming both children every year, beginning with the 25 tax year. Is that correct?
That's correct.
Mr. Avendano, are you aware of any other assets or any other debts that we've not addressed?
No, I am not, Your Honor.
Thank you. Based upon the testimony presented, the court finds that the statutory grounds for divorce have been established. As a result, an absolute judgment of divorce is granted to the plaintiff, George Alfredo Avendano, from the defendant, Alexandria Kimberly Avendano. Court finds regarding the two minor children, parties shall have joint legal custody, father shall have physical custody. The court finds that this arrangement is in the best interest of the minor children. Neither party shall remove the domicile of the minor children from the state of Michigan without prior approval of the court. Each party is obligated to keep the friend of the court notified of any change of address or employment. Mother shall pay support to father in the amount of $103 per month, and that is effective. How do we make that effective? The new support amount. I'm adopting the one for the past.
When was this filing?
It ended in December. I'm going to make it effective January 1. January 1. Support is effective January 1, 2025. Neither party is awarded spousal support. Mother is awarded parenting time as outlined on the record. The divorce judgment shall include the property division that was outlined on the record, as well as any and all provisions concerning tax exemptions. Oh, I failed to mention standard medical insurance provision. Correct, sir?
That's correct.
Standard medical insurance will be provided with the uninsured medical expense be divided pursuant to the percentage stated in the uniform support order. Mr. Avendano, the court is going to execute the judgment of divorce. The support order is going to have to be prepared. Mr. Holdwick will be in the process of putting that together today. We'll have the judgment order signed, and once that is entered, we'll mail a copy of this to you as well as Ms. Avendano.
Okay, thank you so much, Your Honor.
Do you have any questions, sir?
No, I do not.
Thank you. Also, the court should recognize as well, a default was entered in this case back in August 23, 2024. That'll conclude the proceedings. Good luck to you, sir.
Thank you so much, Your Honor.
You're welcome. I'll profess so here. Parties are present. Would you both please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Just like in the last proceeding, I try to make this as simple as possible. So if either of you have any questions, feel free just to let me know and we'll try to get through it. Always begin with the plaintiff first. Miss, would you please state your name and spell your last name?
Tamara Pulaski, it's Pawlows.
And you're the plaintiff in this matter, correct? Have you lived in the county of Huron at least 10 days in the state of Michigan, at least 180 days immediately preceding your filing this complaint?
Yes, I have.
At the time you filed this complaint, was Mr. Pulaski also a resident of Huron County, Michigan?
Yes, you are.
Is it true that you were married on August 17, 2002 in Huron City, Michigan by a person authorized to perform marriages in the state?
Yes, I have.
You stopped living together as husband and wife on or about August 1 of last year, correct?
Correct.
Prior to the marriage, your surname was Young, Y-O-U-N-G?
Correct.
And you've always known, or your husband has always been known as Jeffrey Allen Pulaski?
Correct.
Are there any minor children of this marriage?
There is not.
I have to ask, are you currently expecting?
No, I'm not.
You've alleged in your complaint for divorce that there's been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed, and there remains no reasonable likelihood the marriage could be preserved. Is that true at the time you filed the complaint?
That's the place.
Still true today?
Yes, it is.
Briefly, in your own words, can you explain to the court why you feel the marriage cannot be preserved?
We have too many differences.
Very well. Is there any chance of reconciliation?
There is not.
The court did not grant you an absolute judgment of divorce. Would you be willing to resume a husband-wife relationship with Mr. Pulaski?
No.
According to your proposed judgment, it indicates neither party would be awarded spousal support, and that issue is forever barred. Is that correct?
Correct. Mhm.
Also, personal property, each party be awarded personal property currently in their possession, be fully responsible for paying any debt related to the property, with the other party having no claim to it.
Correct.
And has that already been done?
Yes.
Is there any piece of property that you hold or that Mr. Pulaski holds that needs to be exchanged yet?
Just our cabin. But I've already talked to Greenstone. I have to have my divorce papers first before they'll take his name off.
Okay, that's real property. But
Yes,
we'll get to that in just a
Oh,
second.
okay.
But no, you're fine. But other than that, if it's a four-wheeler, if it's
Yeah, all that's-
an Xbox, whatever it is, it's already been exchanged.
Correct.
Thank you. There are debts to be divided as well, correct?
No.
There is according to your proposed judgment, debts are divided according to the attached personal property debt addendum. Are there any credit card debts or any debts in both names?
No. No.
Are there debts in individual names? In other words, you have your own credit card, Mr. Pulaski may have
Correct.
his own.
Mhm.
Would you agree that any debt that you hold personally in your own personal name would be your responsibility?
Correct.
And the same with Mr. Pulaski?
Yes.
What about the credit card with T1 Credit Union, approximately $1,200?
That should have been taken care of, but I'm taking care of that, Your Honor.
Okay. And a personal loan from Independent Bank, approximate balance of around $7,500.
That's our tractor. I agreed personally with him that he's gonna take care of the payments. It's in my name, but I'm okay with that.
Okay, so there are debts in both names, or at least in your name.
It's in my name, but
But
he has possession of it, yeah,
Okay.
and he paid that.
And it indicates here that he'd be responsible for that debt, approximately $7,500.
Correct, yeah.
Okay. You own motor vehicles as well?
Correct.
Each party keep their respective vehicle free and clear from any claim of the other?
Yes, please.
Are there any vehicles that have both your names on the title?
I have one, but the engine's blowing on it and I'm just paying on it.
Okay. You also own land,
Mhm.
and is that the cottage or the
It's
other
the cabin, yeah.
cabin you're referring to?
Mhm. It doesn't have a physical address, it just has a parcel number.
All right, the home's at 725, correct?
He owns that home now. We already refinanced that.
Okay.
And put it in his name. I took my name off the deed.
Okay, so 725 goes to your husband,
Yeah,
8830 goes to you.
correct.
Any debt owing on either the parcels?
I mean, we have a mortgages, but the mortgage is in his name for his house and the mortgage is in my name for my house.
Because you said you did refi.
Yeah,
Okay, great. Any pension, annuity, or retirement accounts?
Yes, we do, but we're keeping our own.
So each party would be awarded the pension, annuity, retirement account in their own respective names
Correct.
and hold it free and clear from any claim of the other.
Yes.
Are there any life insurance policies that carry cash value? In other words, these whole life policies,
We don't have a whole life. We have a 30-year
term.
term.
Is there any property that I might be missing?
No,
Do you wish to have your previous name or another name as your surname?
I'm gonna keep the last name.
Okay. And you're entitled to that.
Mhm.
I'm just trying to save you money in the event you did want to change.
No,
I think it's a little
okay.
over $300 to change it. Any other assets or any other debts we've not covered?
No, there's not.
Thank you. Sir, would you please state your name?
Jeffrey Allen Plosky.
And you're the defendant, correct, sir?
Yes, sir.
Have you heard all the questions and all the answers that have been provided so far?
Yes.
Regarding the property, is that your understanding of the settlement between you and
Yes.
your spouse?
Yes, Your Honor.
Are there any other assets or debts that we've not covered? And are you asking that this be entered as well?
Yes, sir.
Based upon the testimony presented, the court finds that the statutory grounds for divorce have been established. As a result, an absolute judgment of divorce is granted to the plaintiff, Tamara Dawn Pulowski, from the defendant, Jeffrey Allen Pulowski. Make a finding there are no minor children of the parties, neither parties awarded spousal support. The divorce judgment shall include the property division outlined on the record, as well as any and all provisions concerning pensions, life insurance, and the proposed judgment comports with the testimony that's been presented by both parties. As a result, the court is entering the judgment of divorce today's date. And what will happen next, folks, is this document will be taken to the county clerk's office. You'll be able to get a copy of the judgment today. And I wish you both the very best moving on.
Thank you.
Good luck to both of you. Thank you. Awesome. Parties are present in the courtroom. This is Mr. Ludington's motion. Will both parties please raise your right hands?
We went through this before, Your Honor.
I'm sorry.
I don't believe in God.
All right, well, I can ask, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Sir?
Yes.
It's not that hard.
No, Your Honor, I just want to make sure we clarify,
No,
so that way I'm
no.
not like agreeing to something, you know.
No, I respect that. I respect it. So, Mr. Ludington, what's going on here, sir?
Wait, Your Honor, like I said before,
Wait.
I would like to adjourn this meeting because I'm in the process of obtaining legal counsel.
Oh, okay.
And I had a meeting with my lawyer on Wednesday, but he could not be here this morning, so he asked me to request for adjournment.
Okay, who's the attorney that's going to be representing?
Benjamin Onsworth, I can't pronounce his last name. I'm so
Okay.
sorry. He's out of Port Huron.
All right. When is he going to be available?
I'm supposed to
If the
call
court
him
agrees with this.
Monday to let him know what you agreed upon, if you agreed to for the adjournment or not, and then I can contact the court, or he can contact the court to let you know that we will be available soon, like next week.
All right. What is your current address?
It is 460. I apologize. I was gonna give the new address to the court when we were done.
Okay. Mr. Mr. Ludington, what's your position on this request?
No, we're here today. She's had ample time to get an attorney to be here. I want a decision on this today. I've been dealing with this with her, taking my daughter to wherever she wants around convicted sexual predators. And every week, as in the motion, what I'm dealing with every time. They don't have a vehicle, and then they move from Bad Axe, Sandusky, Croswell to way down on the other side of 94th, and they don't even have a vehicle of their own.
Who's the child with right now?
Me. I've had her for almost the last month when I went to get
2
her.
weeks, you've had her.
No, I got.
You've had her for.
Wait, we're not getting into an argument here. I'll grant the adjournment, however, the child is to remain with father until the next motion here.
That's
Thank
fine.
you.
Thank you, Your Honor.
Wait, let's get a date now.
Oh,
We have
yes.
everything set. So, Mr. Holbrook, the prior order regarding custody and or parenting time is suspended on an interim basis until the motion is heard. The child shall remain with father. March 7th.
March 7th, that's fine.
Is that acceptable to you, sir?
Yep.
Stand by. We're going to give you notice right now. Yep, we're going to give you notice right now. So we'll go off the record and we'll see you March 7th. Just hold on just for a second. EP, this is the defendant's motion regarding parenting time. And I believe, did we not adjourn this one because some party was going to get counsel?
That is correct, Your Honor. Counsel was, the adjournment was sought the last hearing for, I believe, the counsel.
All right. Ms. McIntosh, is your attorney here?
No, he could not make it today. So I'm not asking for another arraignment. We've discussed it. I've gone through the hearing with them. I am confident in what I'm going to do today.
Okay. All right, so we'll proceed. Off the record just a moment ago, Ms. McIntosh made a statement, and it was not, as I stated, not on the record, so I need to hear from Ms. McIntosh. Place on the record, well, let me place you both under oath first. Would you both please raise your right hands?
Are we going
Accept,
to
I accept, yes.
do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes. And I have witnesses outside, Your Honor.
I'm sorry, I didn't hear your end. Okay. All right, go ahead, though. What do you want to tell the?
That Mr. Luddington threatened my boyfriend, Michael, outside because I did not agree to the custody that he wanted, that he would put him in jail today.
Who would put who in jail?
That Mr. Luddington would put Michael in jail today.
Okay. Did you report it to police?
It just happened today, Your Honor. I was waiting for my turn because I was taught you do not interrupt the court when they're in other court proceedings.
Oh, no, you could walk out of the courtroom and contact police at any time if you believe there's a violation of any criminal law. I didn't hear it, I didn't see it. I'm not here to question it, but if there is an issue relative to that, contact the authorities.
Okay.
Sure? Okay? So you may be seated. You're
Yes,
fine. So we are proceeding.
And again, Your Honor, my witnesses are outside. Can I go get, not like outside, but just outside the courtroom? May I bring them in?
Well, wait, just a moment. Let's address the motion first.
Okay.
Let's address the motion first. We'll see how we proceed in that regard moving forward. Mr. Luddington, why are you requesting parenting time being changed?
Why am I? Because she has not a stable home. She bound in the last year, she's had over 4 different addresses on court records so that I can show. She takes the children, allows them to be around people that are convicted of criminal sexual conduct, 4th degree, between which under the law, it's 13 to 15 years old, which she allows my daughter to be left in the care of this person, in which I have an order.
What's the person's name?
His name is Michael David Sims.
Is that the individual that's outside?
Yes.
Yes, Your Honor.
Oh,
Oh, my bad.
So, Mr. Sims, you heard the allegation here just a second ago. What's your position as to what happened?
I'm not Mr. Sims.
I'm sorry. I'm looking at the wrong file. Mr. Luddington. Mr. Luddington, give me your account of what you believe happened in the hallway.
In the hallway, I got the court order for a personal protection order, which I'm gonna file asking you to do. That's what he's gonna go to jail for if he violates, because I'm asking the court to instate it. Because he has no business to be around my 4-year-old. Being a criminal, sexual predator that coerced a 13-year-old in trying to have sexual. It's in the paperwork. It's on his MDOC. There's no denying. That's what I'm asking.
So
She won't protect my child.
Threaten?
No, I didn't. I told her what I had a paperwork. I'm getting filled out. If he doesn't comply with it, he could go to, that's what would happen. He would go to jail.
If the court grants it.
Yes, that's exactly, sir.
Okay, so you're alleging, and we'll get your response. No stable home,
No,
according to you, 4 different addresses within a year. Takes the kids around sexual predators or offenders.
Yep.
Specifically, Mr. Sims. Your daughter is being watched by Mr. Sims alone. That's your
Yep.
allegation. Anything else?
no, that'll be it.
And is it week to week?
It's supposed to be week on, week off.
How old is the child?
She'll be 4 the 11th.
Is the child in preschool or?
No, because she won't allow me to get her vaccinated because she won't give me a social security card or nothing, which I'm in the process of getting, so I can get her into school. Her other children are not in school either. I want my child to have an education, Your Honor, and it's becoming a battle, and I want to protect her, and I just don't, I'm asking the court, because this is not the first time I've had to come to the court to even get my child back on, week off, when she would take off to wherever and not bring the child, tell me where the child was so I could come pick her up.
Now, if I recall correctly in your motion, you had stated, and tell me if I'm wrong,
Yes, sir.
that you went to the home where you believe Ms. McIntosh was to pick up the child, but then you found out that a week prior they had moved.
No, I didn't find out till that night they moved.
Right.
Yes.
You
With
found out
Sergeant
that
Woodruff.
you
Yes.
found out that they moved out a week prior. No,
Yes.
you didn't find out a week prior. You found out that day that.
Yes, sir. Yes, sir.
Okay. And where was that home originally?
665, I believe it is.
Here in
Van
Huron.
Dyke right here. And
FedEx.
FedEx, yes.
Okay. And tell me about this vaccination issue.
I'm trying to, she, for some reason, will not vaccinate none of her children. I want mine vaccinated, like I got a 15-month-old in the house too, daughter, and she is vaccinated with everything that's going on with the measles and everything. Your child, and we can't even get them you can't even put your child on online K-12 without vaccinations. And she just fighting me every step of the way, won't give me she gets WIC for the child and still will not have the child vaccinated.
And both parties, you both have joint legal custody.
Yes, Your Honor.
Decision-making power. Okay. Are you exercising the week on, week off currently?
No, I've had her for the last
Okay.
6 weeks, I
What I
believe.
thought. I just want to make sure.
Yes, sir.
Okay. Anything else you want the court to consider before I go to Ms. McIntosh?
No, sir.
Okay, Ms. McIntosh, go ahead.
Okay, so the issue with Michael, Earl has known Michael is a sex offender from the day that me and Michael decided to get together. Me and Michael are not just boyfriend and girlfriend. I have 3 other children by Michael that are Rebecca's siblings. He has never been left alone with Rebecca because we live with other people. And I ask Emma or Jason to keep an eye on Rebecca. So I don't understand. And my other father of my children don't have an issue with Michael being a sex offender either. And now all of a sudden Earl wants to bring it up to the court's attention because I'm not giving him what he wants. And for
What do you believe you want?
he wants full legal custody of my daughter and he's not getting it. And for the immunizations, Your Honor, I have 2 copies, 1 copy for you, 1 copy for me of my daughter Rebecca for her to go to school. And then I've already talked to the school. I can get her enrolled today as soon as I get custody back of her. So Earl can have her every weekend from Friday to Sunday. They said that I can enroll her as long as I have the immunization waiver. Earl is not even on her birth certificate. So I don't understand why he's trying to enroll her into school. And I have,
He has joint legal custody,
yes, Your Honor.
so he has the authority.
But I have shot waivers for every one of my children, and all of my children are in school besides Rebecca and Samus, because Samus is 6 months old.
Public school?
Yes, Roy is in the ISD school. Phoenix is in the early on. Monica and Joshua are in Cleveland Elementary School.
You said the ISD, you pointed over here.
Yep, Roy's here with his dad in the ISD here in Bad Axe with Phoenix. Phoenix is with her dad, Michael. They go here in Bad Axe. Samus will be going as soon as she hits 1.
Okay, I got it. I think I understand.
So, and I don't understand why he has to fight me. When I tell him no vaccinations, that means no vaccinations. None of my children have vaccinations. And I have the waivers to prove that she can be into school without it.
All right.
And Your Honor, he also stated that I do not have a vehicle. And I have my application for my Tahoe that I had previous, and then I have a Durango right now in my name. So I do have a vehicle. And the registered sex offender that he complained about in the 2 registered sex offenders in the trailer park where I live with my daughter, Rebecca, I have the application for the trailer park. It asks you if you are a sex offender. I did not know there were sex offenders that were in the park when me and my child moved in because I was asked if we had any felonies, sex offenders, or any traffic violations, because this is federal housing. So I don't understand how those sex offenders got in there, but I have contacted the management and I have requested the removal of those sex offenders in the trailer park.
Removing the individuals from the.
Yes, because it is a federal housing. They're not supposed to be there. So that's what, and so I have contacted the management and requested for them to be removed out of the trailer park. And Michael is not living in the trailer park with me and Rebecca. He lives here in Bad Axe with Roy, Phoenix, and Samus, his children. But I have sole legal custody of all of my children but Rebecca. Sole legal and sole physical custody.
And that could explain the difference why the other children can be around a sex offender when you have joint legal custody and father's saying he doesn't want that.
Right.
You may be serious.
Yes, sir.
This is what the court is going to do. This is a motion regarding parenting time. What I'm hearing, and I acknowledge, the court acknowledges here that this is really more than parenting time. This is custody. Not only physical custody, but legal custody. The parties currently have joint legal custody. I believe mother would have joint physical. They go week on week off, we're supposed to.
He has physical because when we started this, Your Honor, I had a medical condition when I was pregnant with Samus. I had a cyst and it was growing and I did not.
I get it. I don't want to hear from the president.
There was a judgment and order of affiliation and support that entered on March 7th, 2024. That order was stipulated to grant both joint legal and joint physical custody. Real time on a weekly basis.
Okay. I failed to ask this, Ms. McIntosh, but you were living in the Bad Axe area?
Yes, Your Honor.
And you moved to Port Huron area?
Yes, Your Honor. And he knew I've been looking for a place to live.
I just asked the question.
Oh, sorry. Go ahead.
I was just answering my question. And you understand that if you have joint legal and joint physical custody and you're living in Port Huron and father's living in Huron County.
Father's living in Tuscola.
Well, Tuscola, Huron doesn't make a difference.
Sorry, Your Honor.
But what it comes down to is when the child starts school, the child can't go to Port Huron schools on week 1 and then to a Tuscola County school on week 2.
Yes, Your Honor. That's why I want my physical custody and he can have her every weekend. Like every weekend. I will even do all the transportation and drop her off and pick her up. He can have her every weekend.
All right. Well, this is originally a motion for parenting time. The court finds that this is really a motion for custody. The court finds that there is a change in circumstance that would warrant the court to review review the custody factors, in this case, the best interest factors. The change in circumstance is the moving of Ms. McIntosh to Port Huron, the acknowledgement of Mr. Sims being involved, having a relationship with the plaintiff. Mr. Sims, according to both parties, is on the sex offender registry, which is a concern of the court. And as a result, I find a change in circumstance, which would warrant a review of both physical and legal custody. The court is addressing address the physical custody because also we have the issue of where the child will be going to school in the fall. Number two, regarding legal custody, there is an issue between the parents relative to vaccinations. And the court's position and the law is relative to disputes regarding legal custody is that if the parties disagree on significant or very important issues pertaining to the child, whether it be education, even religion, and medical issues, this being a medical issue regarding vaccination, that there is certainly that factor that needs to be considered by the court. And when those situations arise and the parties cannot agree, there is a very good possibility that only one parent will get legal custody. So the idea here is for the parties to attempt to agree to the best extent they can in the best interest of the child how to move forward. If the parties cannot agree, then a legal custody motion, which the court now finds in this matter, will be addressed. And with the front of the court investigation, they will make the recommendation to the court and to the parties as to what they believe is in the best interest of the minor child. When that report is prepared, either party can agree with it. If they disagree with it, to file the proper paperwork to say they disagree and why they disagree. And then we have a hearing to address custody, parenting time, as well as physical and legal custody, and also support. Because if the custody order is modified and one party has more time over the other, then the support issue needs to be reevaluated as well. So that's what I'm going to order. In the meantime, at this point, I'm going to continue prior orders regarding the parenting time. Actually, Dad, what's your position on that? Do you wish to?
I want to keep her till the next court date until.
Well, that's going to take some time. And I don't want to.
I'll let her come visit, whatever, but I'm not letting her go. I shouldn't have to allow her to take her and not bring her back. I mean, I got her in my custody. Why should I have to let her go and not get her back?
My custody, miss my time.
That's what I'm asking the court, because this happened before.
I
when
have
she
missed
took
my
her
time
and then
with my
wouldn't bring her
daughter
back.
already. I would like it to go back to the way it was, week on, week off.
Court's not going to do that because
Thank
there's
you.
an issue regarding Mr. Sims.
Thank you.
He's not living with us, so I'm living in Port Huron. So I don't understand why Mr. Sims is the issue. He stays here in Bad Axe with his 3 children, and me and Rebecca, Joshua and Monica are in Port Huron.
I will allow on an interim basis parenting time, 8 hours every other weekend. Mr. Sims is off limits, completely off limits. Anyone on the sex registry is off limits. The 8 hours can either be Saturday or Sunday.
So does that mean his best friend can't be around her either because he's a registered sex
I
offender?
don't have nobody around her, Mom.
Brian is a registered.
Hold
sex
on,
offender.
Miss, I've had enough.
Thank you, Your Honor.
I've had enough, please. There's
I'm just
proper,
trying to understand my position here. So.
well, let me
Michael's not-
finish. Let
Okay.
me finish. And then if you have a question, because if you've noticed in previous hearings, I've asked, do you have any questions? That's the proper way of doing it. Interrupting the court is not the way to do it.
Yes, Your Honor.
Thank you. 8 hours, Saturday or Sunday. And both parties have transportation. Dad, is it easier for you every other Saturday or Sunday for 8 hours to bring the child over or to pick up the child?
I can do either. I have.
Either? Okay, how about you, miss?
Either, doesn't matter. Your Honor.
Okay.
I
Well,
mean,
court will follow its policy that when you want the child, you pick up the child. And when you return the child, the party that is to receive the child picks up the child. So Ms. McIntosh, you will go to Mr. Luddington's or a mutually agreed location to pick the child up, either Saturday or Sunday. We need to figure out which day and what the hours will be. And then at the conclusion of that day, Mr. Luddington, you will receive the child and take the child back to your residence. That'll be every other Saturday. Can we begin it this Saturday? Both parties are nodding. What time on either Saturday or Sunday? Which day is better for you, miss? Saturday or Sunday?
Whenever day I can pick my
I
daughter.
have a question. We do it Sunday? Because I have a birthday party while she does for her
either
9-year-old
day.
friend Saturday.
She said either day.
So if we do Sunday, great. She got a birthday party Saturday, but hey, if she, it is what it is.
What times do you prefer for the 8 hours?
You mean from noon to 8?
Want noon to 8?
Yep.
Sir?
That's fine.
Noon to 8. This Sunday, noon to 8. What will happen is Ms. McIntosh will pick up the child at noon. Mr. Luddington will pick up the child back. Well, hold on here. It's only 8 hours.
Your Honor, if
I'm assuming you'd be staying in the Port Huron area the 8 hours, or would you head back?
Well, I got somewhere in Yale, around there, K-Pac area. I can,
So you
I'll
can
make
do
it
the
work.
transportation.
yeah, I'll make it work.
Okay. So he'll do the transportation then. The court changed its ruling then.
What address do I take her to?
Address, please.
4-1.
And then I pick her back up at 8 o'clock on Sunday night.
And that will continue as an interim order until we have the custody, parenting time, legal physical support report or recommendation. This Sunday.
Mr. Luddington doing all transportation or only transportation for this weekend?
Let's switch it off. I mean, she wants to do it. She can come pick her up and
We'll
I'll,
alternate the transportation.
yeah,
You okay with that? So this Sunday,
I do it all.
you do the transportation all. Next week, or the 2 weeks after that, you do the transportation all.
Yep.
That's how we'll do it.
Yeah.
If, I know the parties had agreed for parenting time this coming Sunday, if they can't agree, is the default period Sunday from noon to 8?
Yes. Yes. So if you agree on another time, mutually agree, that's fine. Court has no problem with that. But if you don't agree, it's noon to 8 every other Sunday, beginning with this Sunday. Questions? Yes.
Yes, Your Honor. So now that it's stipulated that Michael's not supposed to be around her, but his best friend Brian is also a sex offender, is he not supposed to be around her either?
You have to file a motion for that.
Okay, and then
File a
another,
motion.
one more question, Your Honor.
Go
Can we
ahead.
transfer this to St. Clair County, because that's where I live?
You have to, well, you've lived there how long now?
Since January.
All right, file a motion. You have to file a motion for that as well.
I have to file for motion as well?
Yes.
Thank you, Your Honor.
Yep. Any other questions?
No, Your Honor, I'm so sorry for interrupting.
Appreciate it. Thank you. Do you have any questions?
Nope.
Let's see how this goes. Good luck to both of you.
Thank you.
Off the record. Oh, yes, both parties, would you stop by the front of the court's office to pick up your packets? These are packets that you need to prepare for the front of the court to do their investigation. There are objections relative to a support calculation by Mr. Rhodes. And mother has filed a motion regarding parenting time as well. Parties are in the courtroom. Would you both please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes. Thank you. Mr. Holman, can you give us an update, please?
One second. Your Honor, Mr. Rhodes was to be paying child support to Mr. Rhodes for the last quarter in the amount of $220 per month. There was an objection to that calculation. A hearing was held. The objection was denied and the order had entered. Since then, Your Honor, the front of the court has received information from Ms. Rose regarding incapacitation status. And my understanding from the file and Ms. Schultz is that the issues of incapacitation or the conditions were met for incapacitation, an abatement notice. And Mr. Rose is objecting to the abatement of child support during the incapacitation period. Okay. So for that, and then Ms. Rose filing a motion for parenting time. And I'm not sure. I believe the parties have Parenting time on a week-to-week matter. Order. Yeah, parents time year round on a week-to-week basis.
All right, Mr. Rhodes, you're under oath, sir. What is the objection?
I didn't
regarding this?
object to it. The last abatement I had was, I overpaid child support back when I received it, and I got an abatement, or the court issued it because I overpaid it, and now it's held in abatement. But the objection to regarding child support wasn't from me, it was from her. Not from me, from mom. And at the time, I would, of course, got fired. And her order was taken from starting August the 1st. But it was never $220, because at the time, only one minor is included in child support. Everyone's 17 years old. And I got fired. It took me a couple months. I was on cash assistance, and I couldn't. And she had to pay that from August 1st. I only got like 4 payments of that, and I was only about $173. But the abatement was because I overpaid on child support, and that was from whatever y'all issued or the system that gave me.
Right, but your objection now is the abatement of her support.
I didn't really object. I don't really care about support.
Okay.
You know my matter from when you was a lawyer, and I didn't really care about the child support that much. But when me being late, of course, laid off now, her not being able to work at this present moment, my idea was it switches so much. And I talked to the EHS about this about a week ago, that she claimed one on for food stamps, for example. I claimed one on food stamps as an example. And because both our pay changed back and forth, and it prevent us from keep on coming back here.
Okay.
And there's nothing in the MCL that's stating that that can't be done. And the DHS would, or DHA, yeah, whatever, would agree to it, but they stated that, that the food stamps that we would have to agree or to change it are a court order.
Okay, but you're objecting to the support being abated from mom to you.
Well, I didn't mean to word that way. I don't.
Well, I mean, you wrote she's not incapable of working. She
cleans, even though she uses it. She can't handle chemicals right now because of being pregnant. But she was cleaning the martial arts studio to pay for the kids, my son's karate.
Mr. Holden?
Just for the record, Your Honor, January 17th, 2025, a notice of redirection or abatement of child support was sent to both parties. It stated the most recent support dated August 30th, 2024. In front of the court will be taking the following action regarding the support charges. Abatement of child support, current support order, minor children will be abated to 0 because it is reported that the payer will be incapacitated as defined under the current subsequent Michigan child support formula for at least 180 days. That same order mentioned if there's an objection within 21 days, a hearing would be set. There was an objection, whether that was by Mr. Rhodes filing, if that was the wording. Either way, it was interpreted by the front of the court office as an objection. Right. And Ms. Schultz had set that for today based upon that objection.
But it doesn't sound like he's objecting now.
I never got no abatement on those now.
I just wanted to notice to be, or the record to be clear on that, Your Honor.
What is the house number where this information is sent?
The abatement was sent to 153.
Is that where you're at, sir?
No, Your Honor, I just recently changed my address, and at that point, when it was sent out in front of him, I was still living at 153 until the second week of February.
Ah, maybe that's why.
I never received it in the mail.
January 17th, it was put in the mail, so whether it was, I don't know if the forwarding address was made or the post office made it, I'm not sure.
Did you provide the post office?
Yes, it did, but at that time, I was still at 153.
Okay, did you inform the front of the court of your new address?
Yes, I did.
Good, good. Okay, well, it's abated, so, but you're not objecting to it now.
I'm not objecting to it. I never actually meant to object to it. I just, the circumstances of her emotions, it just didn't seem right to me. That's why I gave that answer.
Okay, well, let's go to mom's motion then. What's the issue regarding parenting time?
I have attendance records for both children. I have reports from CPS and a CPS worker here testified.
And what are you alleging?
I also have a letter from the school stating that the youngest minor was left at school twice on dad's time.
What are you requesting?
For weekend visits only.
Mr. Rhodes, do you have any response to that, sir?
Yes, granted October 22nd, and he was left. My daughter was supposed to pick him up. She got delayed and didn't pick him up. On it states here, if you look at the app log, if you do have, school said they tried to call me, but there's no indication of the call log, which is also showing that they didn't try to call me. I charged her the call log. I notified a friend in court the call log, and she states on page 1, 818. So they would have your number of them, your word, you have to have a signal and show they called you. It's like voicemail, but I had no voicemail. On page 2, the oldest son, she kept asking about the 8-year-old. He stated that
Well, I can't go to what the child stated. That's your
no, he asked about the 8-year-old. But also the older, the 17-year-old, that did state, which
I can't hear.
I know it's on the app log, that he several times has not wanted to go with her. And
Sir, is there a pending CPS investigation going on right now?
I have no clue. I haven't seen them since November.
Okay, Miss, is there one going on right now?
To my knowledge, yes.
Do you have the caseworker here?
Mhm.
Miss, would you please step up to the witness stand? Please be seated. Would you please state your name for the record?
Stephanie McCollum.
And are you employed?
Yes, I'm employed at Michigan Department of Health and Human Services as a children's services specialist.
And what does it mean to be a children's service specialist?
Specifically, I investigate allegations of child abuse and neglect.
All right. Are you familiar with the Rhodes family?
Yes, I am.
And if this is not offered for the truth of the matter asserted, were you called to investigate something regarding this family?
Yes.
What was the nature of the call?
So this was several months ago. There were concerns regarding an individual that was residing in the home with Michael, as well as concerns about potential access to substances in the home. And some behaviors that Seth had exhibited that resulted in placement in a mental health facility.
All right. And you said this was several months ago?
So there was 2 back-to-back. I believe one was in the summer and one would have been, I think the most recent one would have been
November.
Oh, excuse me, sir. All right, hear from the witness. November?
I believe so.
What was the nature of the allegation November 8th?
I believe that was the one in which there was concerns about the substances in the home.
All right. And did you investigate that?
Yes.
And well, as a result of the investigation, was a case service plan?
According to Michael Burroughs' children, there was not a preponderance of evidence found to support allegations against Michael.
Okay, so, and then as a result, that investigation was closed.
Regarding Michael, yes.
Okay. Is there something else regarding another individual?
There was another individual who was residing in a home that had other minor children involved. That investigation was substantiated regarding those minor children.
And was that in the summer of 2024, or was that in the November one as well?
They would have been the November allegation.
What happened to the individual that was allegedly with Mr. Rhodes in November?
She is now moved out of home.
Okay. Is there any issue relative to the minor children currently with Mr. Rhodes based upon the removal or this individual being out of this home?
There are no pending or open investigations.
Okay. Any concerns relative to the children with father from your investigation?
Our biggest concern was the other individual in the home. We do believe that with that individual leaving the home, that those concerns have been mitigated.
What's the individual's name?
Christy Anderson.
Please spell Christy. If you,
Yep, CHRISTY.
okay, thank you. Stand by. Any other allegations regarding the home with this caseworker?
No, no, Your Honor.
Miss? No, you may say that.
Thank you.
Anything else?
I have a report from the martial arts studio that the younger minor attends. As
Regarding support, that issue's already been addressed.
Okay.
Yep, we don't need to address that. Ms. Rhodes, according to the testimony of the witness, the CPS worker, the individual that was involved in this matter is out of the home and there are no issues, and there are no safety concerns. Anything else?
No.
She's been out of home actually since the second week of November. After he went to the hospital, she came to a safety plan when he was released. And that's like last time I saw them. And a day or two later, he left the home. Once I verified.
I'm going to interrupt just a second, Mr. Rhodes. I'm sorry, but is there any objection to both parties agreeing that Christy Anderson is off limits with the family?
Correct.
Any objection? Any objection?
The boys have come back and said she's been in the home for a visit.
He has no problem with having her out.
And she wasn't there. Only time she actually been there to get her things.
Okay. I'm assuming you want her out of the picture as well. Correct. Court is going to order that Christy Anderson is off limits regarding any contact with children, any way, shape, or form. She's not to be in the home, not to be around the children in any way, shape, or form. The motion for parenting time is respectfully denied. The issues that brought the motion to the court's attention have been addressed through Ms. McCollum, through her testimony. We already addressed the abatement in support. That issue has been resolved as well. Prior orders will continue in this case. And one thing, Mr. Rhodes, and I don't need any explanation or anything like that. If there are certain appointments or certain times that children need to be picked up, that's your responsibility on your time. It's her responsibility on her time. That's all I'm saying.
That's fine, but can I ask you a question? When you're done.
I'm Mr. Holden.
Just for purposes of the order, Your Honor, so is the objection withdrawn?
It's withdrawn. Okay. He said he had no objection to it. Go ahead with your question.
The order, even though he's technically not a minor anymore, would like to address the court.
Is he still in school?
Yes.
Still part of the court yet?
Okay, yep. He told me to ask.
Yep, no problem. No, he's still part of the court. That'll be all. Good luck to both of you.
Case is the truth, the whole truth, nothing but the truth, so help me God.
All right, thank you both. I read the motion. I read the response that was just submitted as well. And we won't mention the child's name, W. That's all we need to refer relative to the child. How old is W, Miss? 12. Okay, I read in the motion, the issue pertains to the animal.
Correct.
And Ms. Vajinski, was there some sort of unwritten agreement that one party would have the dog, the other would have the cats?
No.
No? Okay. Was there an agreement in your mind that the dog was to go back and forth?
Where W went, the dog went, and that was initial. And then it changed after that because we came to an agreement that when the kids go just on Thursdays, that it wasn't worth taking the animal with them just for Thursdays, just to bring them back. Because they only would go after school and then they would be back to my house. So then it changed to be only on the every other weekend Thursday, returning on Monday.
But that wasn't in any written document?
That was a verbal agreement between him and I.
You've heard the old saying, a verbal agreement is not worth the paper it's written on.
I have, however, this is causing significant stress and anxiety on W. I do have a paper from his counselor
And I was going to ask about that. It's hearsay. I would need to have the counselor in the courtroom to testify relative to that. But Dan, what's your thought about this?
I mean, it's been a month and a half since he's brought it up with him. Yes, he was upset the first time, but there's been no negative impact. I think only positive impact. There's no distraction with the animal or school. He doesn't, while it's his dog, while he claims it, he doesn't always necessarily take care of it on his own. I mean, as a 12-year-old.
Sure, I get that.
So, I mean, I don't think there's any negative impact. And talking with the counselor, she does see it as a sense of, comfort for him, but doesn't agree that it's a need. So.
Well, what if the letter indicates otherwise?
And it does.
That would be different than what you told me.
Okay, that's why I need to have the counselor in to testify. That's the only way to resolve it.
It definitely indicates that, and the conversation that I've had with the counselor is completely different than the conversation that we've had. W is constantly asking me every single time and asking, he's texted Aaron before and I have copies of that. Can I bring the dog? Answer me, please. Can I bring the dog? I'm not coming unless the dog is coming.
Let's get it from the horse's mouth. Let's have the counselor can appear by Zoom. And what we'll do is we won't put it on YouTube. I don't need to do that. And we'll hear from the counselor. You'll have to subpoena that individual or they'll agree to come in. But can we have a date, Ms. Hatch? What is the individual's name?
Gina Burkhart.
And where does this individual work?
Lakeshore Therapy.
How about March 7th? That'd be acceptable to both parties. And you can both appear via Zoom. We'll make it simple. That date acceptable to each of you? Okay, March 7th, 9 a.m. Call in via Zoom, easier for a purpose of a short hearing like this. The therapist or counselor can dial in as well. And have you ever used Zoom before?
Yes.
Sir? Our Zoom number is just simply our telephone number, 989-269-7112. No passcode, no nothing required, make it very simple.
And do I just give her the information or do I have like the subpoena?
If she is not willing to come in to testify on her own, then you have to. That's how we do. I'm not doubting either of you. This is an FOC show cause allegation against the plaintiff. Both parties are present in the courtroom. Would you both please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Thank you. Mr. Holtwick, allegations of denied parenting time?
Yes, Your Honor. March 22nd, 2022, an order had entered regarding custody and parenting time. Pursuant to that order, the parties, plaintiff has sole legal and sole physical custody of JAR. Parenting time pursuant to this order was on a gradual progressive phased parenting time. It appears there were 5 phases. The front of the court office had received a complaint from the defendant stating that he has not seen the child since I believe it was summer of
23 when it states.
Correct. Based upon that written complaint as well as the previous order of the phased parenting time, not knowing what phases they were on, so on and so forth, the matter was set for a show cause today before the court regarding the issue of denied parenting.
Do you have any indication as to how many phases may have been completed, if at all?
I do not. The written complaint, my understanding of the complaint, and the parties can correct me if I'm wrong, but I understand from the written complaint that we received, there was mention about stage 1 or phase 1 being the 2-hour supervised, and that he wasn't even getting that. So just from the written complaint, I view that phase 1 wasn't completed, but again, I would refer to the parties for clarification.
All right, but the order came in March of 2022, correct? Okay. Mr. Esparza. You've not seen the child since summer of 2023?
Yeah.
Have you seen, how often, up until the summer of 2023, did you see the child?
Here and there, because I would go to like the school football games and I would see him there,
But there was a schedule for you to be with the child, correct?
Yeah.
Okay, did you follow the schedule?
we tried. Yeah.
Tried to? Bless you. How old is JAR right now?
13.
13? And so what is the schedule in phase one, if you know?
It was supposed to be 2 hours supervised.
And for how long were you supposed to do that? Not sure? Okay.
I think it was 2 months.
Yeah, Mr. Holbrook's nodding his head, so 2 months. Did you go the full 2 months?
Yeah, I think so.
You think so?
But we'll be missing here and there.
Okay.
If our schedule wouldn't match.
Since summer of 2023, have you asked for the child?
Well, communications were like broken, like non-existent. I would call and I would not get a response.
When's the last time you called to ask about the child, to see the child?
Well, I stopped calling because the calls wouldn't get through. But my sister, she would have communication with her up until Christmas of last year. They were still talking, and my mom came over from Mexico and to visit my sister in Chicago, and they were gonna come up here. But since she didn't give them a response back, they didn't make the trip.
Do you feel the child knows you?
Yeah, he knows who I am.
Okay. Knows of you?
Yeah.
Do you think he feels comfortable around? It's a he, correct?
Yes.
You believe the child feels comfortable around you?
No.
No? Okay. All right, I'll get back to you in just a moment. Ms. Hessel, what's going on here from your perspective?
In my perspective, this case, Jose has gone to Mexico. He has left within some time, a 6 months period, and he would not attend his visitations properly accordingly to what we had agreed upon. It just became inconsistent. There was a lot of his trauma, intimidation clauses towards me. And the last time he visited my son, he walked off on the visit. I have it on recording on my phone. I had recorded it just for, and my son was kind of traumatized and hurt by that. It was a moment of I was playing with my son and I told him, go up and hand the ball to dad, and he started walking off the visit.
Okay.
How
do you communicate with Mr. Esparza?
Okay, I had asked him to use the app multiple times because I didn't feel comfortable with him texting, because there was multiple occasions where he had made implications kind of.
So you don't communicate by app close?
I tried, I came up here actually to do a meeting with him for parenting time, and they didn't know his address, and I had texted him, he had declined.
Okay, hold on just a second. Mr. Holman, is app close been ordered?
Correct. Yes, that same order of phase parenting time.
2022.
Yes, there's talk time and the communication provisions of app close people.
Okay. Okay. So are you using app close? You have to. That's ordered. It's required. You have a smartphone, sir?
Yeah.
Okay. And can you set it up? Okay.
I believe I sent him requests.
I'm sorry?
I think I sent him requests on that app. I think
Okay.
I can.
Mr. Holwick, is maybe after the hearings is something is your tech wizardry is spectacular that you can look into this for us?
I can, if parties wish to stick around for it. If they can't, we do have pamphlets on the app in our office. With the website and how to do things from app close on their phone.
Can you stick around for a couple minutes
Yeah,
to get that set up?
Of course.
Sir? Okay, thank you.
And I guess my other question would be because of the app, the parties have each other's phone numbers.
I have what was his old phone number. I had made my phone private where it only says priority phone calls, like the ones that are embedded in my phone.
What about if there's, let's say the child's with father and there's an emergency and
I guess I really didn't think about it that way, but because I was getting so much spam and anonymous calls, I had set it into a privacy setting.
okay. Well, the party should exchange phone numbers regardless.
I still have his phone
They
number.
should, if there's issues regarding those concerns, they just have to have access to those phone numbers to get the app set up. And at that point, if they're blocking each other's personal phone calls or whatever, that's fine because the app itself has a phone call feature.
Right.
So once the app is set up, that's how they communicate, period. Text message, phone calls, talk time, everything.
What is the schedule for phase one?
According to what we had for phase one was we would meet up at Dollar General. And that's where we would go. During some periods of times, he wasn't showing up. It's where he wanted and how he wanted it. And I wasn't complying, so.
Well, is there any problem with what was previously ordered to be followed?
It was just inconsistency.
Oh, I get that, but
Right.
but what I'm saying, moving forward,
They're like, wow, explain to me what you mean by that, like.
well, you'd be meeting at Dollar General, what is it, 2-hour visit?
Yes,
And you'd supervise?
yes.
You're still okay with that?
He's not okay with it. He feels like I antagonize. I don't have.
Well, if he has another supervisor, he wishes to pay that. You're
Well,
that's another
I
story.
would have liked someone probably appointed, maybe like, because of, the intimidation that I was receiving.
Well, we don't have that available to the
Okay,
court,
so I guess.
unless you have
unless
someone
I'll-
you pick.
Right, I can keep it that way for myself until I do find someone that could be suitable
Okay.
and more comfortable for my son's benefit.
What is the schedule supposed to be though? What days?
It was like 3 o'clock to, I believe, 6 at the Dollar General for 2 hours.
3 hours.
Three.
Phase one, Your Honor.
Well, that's like 2, yeah. 3 or
Supervised
something.
parents time, 2 hours, alternate weekends as agreed to by the parties. If they could not agree, it would be on Saturdays from 3 p.m. to 5 p.m. for a period of 2 months. And it also stated that the phase shall also include alternate midweek parenting time for 1 hour as agreed upon. And if they could not agree, then it would be Fridays from 4 to 5.
Okay. Can you still follow that schedule? Can you still follow it?
I can still follow that schedule. I just have another suggestion, or can I speak? Jose wanted to take AJ home with him on weekends. I had asked when he gets to that phase that if he could have a suitable environment for him, whereas he's living, he's got a bed, he's got license, he's got his own vehicle, you know, all the necessities as I have.
Is that would be like phase 2 or phase 3?
I don't know what phase we were on because he's missed when he went to Mexico and we had to start all over, pretty much.
Phase 3, Your Honor, is unsupervised parenting time. Phase 4 is overnight, starts going into overnight parenting time. Phase 5 is just standard alternating weekends.
Phase 2 is still supervised though.
Correct. It just up from 2 hours to 6 hours.
Okay. This is, I'm all set. This is what we're going to do. We're going back to phase 1.
Okay, that's fine.
We're gonna go back to phase 1.
Start
Let's
over.
do a complete reset. See the
Sure thing.
whiteboard, both of you?
Yes.
The whiteboard is completely clean now.
Sounds good to me.
We're gonna start over, just a whole clean slate here. Start back to phase 1, according to the previous order of March 2022. If the parties cannot agree, you go to the order. Each party, again, reminder, you have to use app close, period, for your communication. Also, I'm not saying it's happening, sir, but she's alleging that there's intimidation involved. I'm not saying it's happening. All I'm saying is, when you come to that time at Dollar General for the visit, take that time with your child
Yes.
and love it and enjoy it. That you're going to be building a relationship with that child. We will only go to phase 2, Mr. Holdwick, if all phase 1 has been completed.
The previous order, Your Honor, does state that during the parenting time, phases may be delayed or accelerated based on mutual agreement. It also states that each phase has to be completed before moving to the next one. So that was already addressed in the original order. And I heard it brought up about out of country vacations, and that was also addressed in that order. The child not leave the United States.
So prior orders will remain in effect. When it comes to phase 3, where you're concerned about the overnights, because this is a show cause against you, you can file a motion to address that.
Okay,
But in the meantime, let's start back to phase 1.
okay.
And you gotta, both of you have to put the guard down, relative.
Right.
I know you've gone your separate ways.
Yeah.
But you have a child in common
I
here.
have a question.
Sure you do.
I
Go
just,
ahead.
my son, he's very, from previous history of abuse. He has a little bit of trauma and remembrance of that. We're trying to work on, that's
Is
your
the child in
father.
therapy?
No, but he
Why not?
has me. Well, it was like a long time ago and he had suggested,
Well, if it's a long time ago, why would it be an issue now?
well, because he's 13, he's more mature than what was beforehand. But my only issue is my child, with the.
Your child. Both.
Yeah, our child with the long periods of absence during the time of like 2 to like 10. It's very difficult for him. I have a hard time with getting him to go see his father. As much as I press it and push my son, how am I supposed to force him to go?
You strongly encourage it, just as you have been, and if there's an issue with it, you may want to talk to a therapist.
Right, no, I agree with that.
But you
completely.
were to encourage a positive relationship between the other parent and the child.
Correct.
Okay? The show cause is dismissed.
I would just be recommending, Your Honor, giving that information, just the child be enrolled in individual counseling session. Given the length of time from exercising parents' time, saying not really knowing.
I agree.
That he should be in some form of individual counseling moving forward, especially with this starting back in phase 1.
Your Honor.
Yes.
Due to the fact, I know it would be prominent for him to be in that, with him going to school till 3 o'clock, and I usually leave for work at sometimes 5 and 9 because I work midnights. I'm not saying it's not a reasonable, accommodation for my son, but with him, he plays basketball right after school, and sometimes he doesn't get home till 8 o'clock because of basketball.
I'm still going to order it.
That's fine, that's
Yeah,
fine.
because
I don't
it's in the
know.
child's best interest.
No, you're right. I just don't know where I would place that.
Sure.
Can I add to that, Your Honor?
Go ahead.
I would, good starting point, I believe, would be talking to the school's therapist.
I could do that. I
The
mean,
school district.
he goes to Ubley. Yeah,
I know they will talk, Ubley has a good counseling program, and the counselor there will make recommendations and provide information on what to do if services can't be rendered further from what she can do.
I can't use the school therapist as a way that, while he's in school, he can't spend an hour of therapy in school instead of going to see somebody personally.
The school only offers so much
Right.
services.
Start with the school, but the child needs to have that issue addressed.
Okay, yeah, that's fine.
Sir, you raised your hand? Go ahead.
That's my train of thought. About the school, would I be allowed to involve myself?
You have joint legal custody, which means no. Sole legal. Oh, no, that's right. You don't have any legal custody.
I can't ask about him in school.
You have his Snapchat.
They're not obligated to do so at this point. If you want to request joint legal custody regarding decision-making and all of that, you can certainly file a motion to address that. Because right now, Mom is sole legal, sole physical. Mom, what's your position on him, father contacting?
I mean, he can go up to the school and watch his basketball games. I don't mind that. It was just the formality at the time because of the position of threatening to, take him to Mexico and the minor, those things. But that would be because I already put my paperwork in at the school. I have given it to them. I would have to go to the school and discuss that with them too.
Okay, well,
And,
that's up to you, but you can file a motion to address it if you want to have joint legal custody.
Okay.
Okay?
Yeah.
Good luck to both.
Thank you.
You're all set. Thank you. Awesome. P. This is a motion to terminate a personal protection order. The petitioner, Wendy Sageman, had petitioned the court back on October 16th, 2024, for a personal protection order against Mr. Sageman. The court reviewed the document that was submitted to the petition. The court granted the request. Since then, the court has received a motion to terminate a personal protection order by the petitioner. And the motion claims, Your Honor, this has been a trying time. Ms. Emily was granted a Make-A-Wish trip. We will be traveling to Florida. It's a family trip, and DeCarlos is wanting to go. It's very important to Emily that her brother comes. Thank you, Wendy. Ms. Sageman, you filed a request for a personal protection order, and you alleged some serious issues, correct?
Yes, Your Honor.
And now what's changed?
What has changed? A lot of it was the trauma from the past that came into the decision that I did make. Carlos has shown that he's grown, he's paid bills, he's become more responsible. He has spent time with his sister outside of the home with his aunt, and they've been perfectly fine. The two of them are bonded at the knees and even at school, because she does interact with Carlos sometimes in the hallways. She does show that she misses him and she wants to spend more time with him.
But Ms. Sageman, this is not regarding Emily, this is regarding
Right.
you. You filed a petition.
When it happened and when the petition occurred, Carlos was out of the home and was staying at a friend's house down the street. Carlos was being encouraged by friends to continuously come back to the home and interfere with, like I had told him Friday, and he kept coming back on daily thing. And then finally, it was suggested to me to do the protection order, just to keep him away from the home long enough so that I could deal with the trauma.
Did he honor it?
He sure did, yes.
Okay,
Yes.
and so you're saying there's no emergency or no threat and harm potentially to you. That's why you're filing this motion to terminate this.
Correct.
So you're saying, you know what may have happened, but that threat is completely gone, and I'm not worried. And God forbid if something happens, look, I don't need a personal protection order. That's what you're saying, correct? Okay. You understand that if the court does terminate this, there's no protection anymore.
Yes.
And God forbid, I'm not saying Mr. Sageman would ever do this, but if something did happen against you, we've warned you that, look, you have a personal protection order in place.
Yes.
And you're willing to take that risk.
Yes, Your Honor.
Mr. Sageman, I don't need to hear from you, sir. But I'll grant the request. I hope it's just not based upon a trip. I really hope it's based upon
We
that
do
when
want
you testified to that there is no threat and harm.
Right, we do want to rekindle our relationship, and we do miss each other and we do want to see each other, but we need to take care of what is in front of us first. And we will be doing it gradually. We're not just jumping right back into a full-blown relationship where he's moving in and, all of that stuff. We are definitely taking it slow.
But without a personal protection order, he could come back home, I guess, if you wanted to, in some respects.
I mean, yes, he could.
As a guest.
Yes, he could. And
I assume he has his own place.
he does. He does.
Okay. That's all I need to hear. Motion is granted. You're all set.
Thank you, Your Honor.
Good luck to you. Good luck to you, DeCarlos, as well. This is an FOC front of the court show cause against Ms. Thompson. She appears via the Zoom application. Ms. Thompson, are you in the Metro Detroit area still?
Yes.
Okay. How is it down there? Getting a little warmer?
No, it's still cold. Still cold.
Okay. Would you please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Mr. Holdwick, what's going on here, please?
The clerk office, Your Honor, had received a complaint from Mr. Allen that he was denied parenting time on the weekend of January 3rd to the 5th, and the weekend of January 17th to the 19th. There is an order in place from believe October 14th, 2022, that granted Mr. Allen alternate weekend from Friday at 6 to Sunday at 6. So there's the complaint for denied parenting time. He has made further complaints that he's been denied longer. However, gave those specific dates as dates that were denied. Mr. Allen did send an email to our office, I believe earlier this week or last week, that stated he had communication with Ms. Thompson and he did get parenting time with the children. The length of time for that I wasn't sure on, as far as how long he had the children, but he did say he was getting some parenting time. But regarding those denied parenting time within weekends in the complaint, Mr. Allen's not here. And also, the children are on Zoom with Ms. Thompson as well.
Yeah, I'm sorry. He just came in here. I just have to go back to the back.
Okay. Ms. Thompson, did Dad not get parenting time those 2 weekends?
What 2 weekends? I'm sorry. I was making my daughter bottle.
Sure, January 3rd through January 5th and January 17th through January 19th.
This year?
Yes.
No, he did not.
He did not get parenting time?
No, he did not. Actually, I haven't heard from him those weekends. The last time they just went with him Saturday. I had spoken with his mama and we agreed for them to go with him during this whole week, and I just got him back yesterday. But before they went with him, the last time that he seen his kids was October 27th. And then he brought it back to me after a couple of days. They brought it back to me, and he didn't bring back their car seats. And I was waiting for a day. I was waiting for 5 days for their car seats, and he never brought them back. And that was November 4th. I still haven't heard nothing from him. After November 4th, we was arguing. We exchanged words. He was threatening me. I have messages of that. I haven't heard from him after that. And his son's birthday was November 22nd. Didn't hear nothing back from anyone. His mother, nobody. Haven't reached out.
So Ms. Thompson, you're stating that it's been radio silence from Dad for the January 3rd weekend and the January 7th.
Yes, correct.
And he's not here.
He never shows up.
Well, he showed up in the past, but he's not here today. Notice was provided.
I also have proof of him threatening me and my man.
Well, we're here because of alleged denied parenting time.
Right. And I'm just
he sent the information to Mr. Holdwick, which I appreciate, but I need to have his testimony. He's not here. I'm dismissing the show cause. Ms. Thompson, if he does contact you, well, I actually put it this way. When you know his scheduled parenting time is, be prepared for the parenting time. If he doesn't show up, document it so that we have a record of it. Can you do that?
Yeah.
Okay. Good luck to you. You're all set. You're free to go.
Okay, thank you.
Off the record.